Heir and beneficiary. They sound like they mean the same thing, don't they? In California, they're legally different, and that difference can decide who inherits and whether the estate has to go through probate. I'm Shanti Sower Jono, a California probate and trust real estate specialist. I work with families navigating probate and trust real estate across the state, and this is one of the most common mix-ups I see in estate planning. So first, what is an heir? An heir is someone who is legally entitled to inherit when a person dies without a valid will. That's called intestate succession, and here in California, the law decides who takes what. Your heirs are usually your surviving spouse or registered domestic partner, your children, sometimes grandchildren, parents, siblings, and other relatives depending on the family situation. Here's a simple example. John dies without a will. He leaves behind a wife and 2 children. California law determines how his estate is divided between them. Those 3 people are John's heirs. Now, what is a beneficiary? A beneficiary is a person or an organization that the person themselves chose to receive assets. That choice is made through a will, a trust, a life insurance policy, a retirement account, or a payable on death account. And a beneficiary can be anyone, family, friends, charities, organizations, anyone you name. Take Mary. She writes a will leaving her house to her son, her investment account to her daughter, and $25,000 to her favorite charity. Her son, her daughter, and that charity are all beneficiaries. So can someone be both an heir and a beneficiary? Yes, absolutely. David has 2 children. Under California law, both children are his legal heirs because of their family relationship. Then David writes a will leaving everything equally to his 2 children. Now they're both heirs because of their relationship and beneficiaries because the will names them. Can an heir receive nothing? Yes, and this surprises a lot of people. Tom has 2 children. His will leaves everything to one child and nothing to the other. That child who gets nothing is still an heir, just not a beneficiary. Now, certain situations involving spouses, community property, or improper disinheritance can get legally tricky, so if that's anywhere close to your situation, it's worth having your estate documents reviewed by a professional. So here's where the probate question comes in. Whether an asset goes through probate depends on the asset itself, not on whether someone is an heir or a beneficiary. Let's start with assets that usually go through probate. A house owned only in the deceased person's name usually goes through probate. An individual bank account with no payable on death beneficiary named E that usually goes through probate too. And personal property, like furniture, jewelry, collections, even vehicles depending on the circumstances, can all become part of the probate estate. Now, what usually avoids probate? Property properly titled in a living trust. Real estate owned as joint tenants with right of survivorship, that passes automatically to the surviving owner. And any account with a beneficiary designation, like life insurance, a 401k, an IRA, a pension, or a payable on death bank account. The named beneficiary receives those assets directly, outside of probate. Here's a myth I want to bust right now. Having a will does not by itself avoid probate. A will is important. It tells the court who should manage the estate and who should receive the assets. But if the assets are probate assets, they still go through probate, even with a perfectly valid will. Let me walk you through a real example. Frank dies owning a $900,000 house in his name alone, a $100,000 bank account with no beneficiary, and a $500,000 life insurance policy naming his wife as beneficiary. His will leaves everything to his 2 children. So what happens? The house and the bank account go through probate as part of his estate. His children are beneficiaries of the probate estate, but the life insurance passes directly to his wife, outside of probate, simply because of the beneficiary designation. Here's the mental shortcut I want you to remember. California law decides who your heirs are, but you decide who your beneficiaries are. So here's what I want you to take away. Heirs are determined by California law. Beneficiaries are chosen by the person who made the plan. A person can absolutely be both. Being named in a will does not automatically avoid probate. And trusts and beneficiary designations are the common tools families use to keep assets out of probate altogether. One more time, this video is general information, not legal, tax, or financial advice. I'm a real estate specialist, not an attorney, so please talk with a licensed probate attorney about your specific situation. But if you're trying to sort out an estate or you just don't know where to start, I would be glad to help. Reach out for a free, no-pressure probate consultation. I'm Shanti Suarjono, a California probate and trust real estate specialist, and I'm here to help your family find the right next step.